morning, everyone. Thank you all for joining us to our breakout session on local restrictions on renewable energy in Wisconsin. My name is Sharif Halawish, and I'm a staff attorney at Renew Wisconsin, and I'll be moderating this panel. The goal of this timely panel is to clarify the distinct roles of the state and local authorities in regulating the siting of renewable energy in Wisconsin. With data center development, electrification, and retirement of coal plants on the horizon, Wisconsin is entering an era of high energy demand and more development of energy generation and infrastructure. The pace of the renewable energy transition across the state has prompted local governments to revise their zoning ordinances to align development in their territory with their land use planning and community concerns. These trends are creating tension between local authorities and renewable energy developers, and everyone involved has a different understanding of what local authority looks like. So in our panel, we are engaging excellent perspectives across the field to try to understand that balance between state and local authority and discuss how developers and regulators can work together to align state energy goals and local concerns. So without further ado, I'm going to introduce our excellent panelists. First, to my left, Eric Callisto is a veteran energy regulatory expert and attorney with years of experience in state government leadership. At the Public Service Commission, Eric served in the roles of commissioner, chairperson, and chief operating officer. So it's safe to say Eric knows the commission better than anyone at this point. During his time at the commission, he advanced critical infrastructure projects in transmission and wind and played a key role in shaping energy policy in Wisconsin. More recently, he served as lead partner in the energy practice of Michael Best, where he has helped secure thousands of megawatts of renewable energy projects. Earlier in his career, he served as assistant legal counsel to the governor of Wisconsin and other leadership roles across the state government. Second, I want to introduce another excellent attorney, Ori Walcevic. Ori is an energy lawyer at Michael Best and Friedrich, where he helps clients permit and manage energy projects. Passionate about clean energy and building energy projects, Ori started his career in the clean energy industry, operating a manure digester in Dane, Wisconsin. After law school, he worked as an attorney at the Federal Energy Regulatory Commission and served as Renew's first staff attorney. Next up is Isaac Eitenbrook. Isaac is the zoning administrator for Outagamie County with more than 15 years of experience across public and private sector planning, zoning, administration, and land development. Before returning to Wisconsin in 2013, he worked in Northern Virginia with Arlington County, Loudoun County, Toll Brothers, and Capitol Green Roofs. He is also a U.S. Navy veteran. Last but not least, David Jakubiak, serving as Senior Vice President at Aileron. David is a strategic communication and community engagement leader with more than 20 years experience in communication and journalism. And in the past decade, he focusing on renewable energy and energy storage at the intersection of policy, public relation, and local stakeholder engagement. So with that introduction, we're going to do a brief round of questions and then open the floor to questions to discuss this issue more. Eric, as someone who has years of experience as an attorney representing renewable energy clients and as a public service commissioner, why do you think it's important that the state have more control over siting of energy development than local government?
So that's what we call a leading question, right? So, and thank you for framing it that way. First, we have to acknowledge that running a manure digester has to be the best professional experience on this table. So acknowledging the fact that it was a leading question and acknowledging my biases, which we all have, right? I worked at the Public Service Commission. I was a commissioner and chairperson there. And then I spent 10 years working for clients trying to get projects approved at the Public Service Commission. So I come from a fairly narrow perspective in that regard. I have done some work at the local level with local permitting, but the bulk of my experience in this area is based at the Public Service Commission. And I think public policy is dictated on these issues initially, of course, by legislation, and the legislature has spoken on projects that are 100 megawatts or larger, right? So, if we go back to the Constitution and who should be making policy, fundamentally, for the moment and historically in this state, the legislature has spoken that projects over 100 megawatts should be reviewed and, if appropriate, approved by the Public Service Commission. And for those of you who are in the weeds on those statutes, or even if you're not, you may be aware of the fact that a project of that size or larger, if approved by the Public Service Commission, preempts any local regulation of that particular project. So it's a very strong statute that gives a lot of power to the Public Service Commission. And I think it's good power, and for a couple of reasons. Projects of that size are really projects of statewide importance, right? They're not serving people just around the corner, right? It's massive energy use or massive energy production that's being served, that is serving people across the state and across the region. So I don't think that kind of infrastructure should be subject to local regulation or local approval specifically. And as to the system that has been created by the Public Service Commission and the statutes that govern it, I think it's really a very effective, transparent, and thorough process. It's an independent agency. I know some people who oppose these projects would disagree with that. When I was the chairperson of that commission, I did not get any influence from the governor on decisions. I did not get any influence from the legislature on decisions. These are staggered 6-year terms for 3 commissioners who all are, whether they are initially, as some are, or whether they became, as I did, knowledgeable in the area. They are independent. They have an extensive staff, expert staff, who are quite good at what they do in reviewing these projects. And I fundamentally believe that if you did not have an agency like that in charge of large projects, you would not get large projects approved. There's just an NIMBY element to these projects that are a massive hindrance if you don't have somebody else approving them. So a long way around the barn to say that I think the system as it exists right now, with potentially some tweaks that we'll talk about, is quite good.
And Ori, as someone who represents clients dealing with permitting and siting issues, what are the main legal guardrails that impact smaller projects that might be out of the jurisdiction of the commission when it comes to wind energy and energy storage, wind, solar, and energy storage?
Yeah, so Sharif kind of gave me the legal question, so I'm going to try and keep it brief, but we've got solar, wind, and battery storage. They can be combined in different ways, but I kind of want to, if you guys imagine like an inverted pyramid of regulation, first you have just your normal county and local zoning regulation that governs wind, solar, battery storage under 100 megawatts to some extent. And the first place you're going to look is to see if you have a use by right or a permitted use in your zoning area. Use by right is exactly what it sounds like. It's a use you can just, it's my right, it's my land, I use it. Single family homes would be an example of that. That's a use by right in some areas. Permitted use means as long as I comply with the conditions and I show the local government that I've done that, they need to issue that permit, and I can go ask for that permit. There's not discretion there. Then you get into where most of us are with clean energy because it's newer, conditional use land. And conditional use is probably the first step, but you also may need a zoning change, which comes with a comprehensive plan change, various approvals. But what's important legally for these items is in Wisconsin, they need to be backed by substantial evidence. So that's the standard that overlays any decision that's going to be made by a local government on a solar project, a battery project, or a wind project. So that's the top level of the pyramid. Then you kind of kick one down. That's where battery storage sits, and that's where solar and wind sit, but that's battery storage loses out in the next level of protection. The next level of protection is the state government has acted to say there's only certain instances when we think it's permissible for local governments to regulate wind and solar systems. So we don't want them, what they've said is we don't want them legislating. What that means is, I find that all solar is bad. That's a legislative determination. We want them making decisions about their locality, but health and safety of projects, and other concerns that you can fit into 3 statutory exemptions, which are really built to protect the right of individuals to site some of these smaller scale projects. And so what you see is these projects need to be considered on a case-by-case basis. And I always get asked, what is a health and safety reason? And I think back to the distributed solar context. Some building codes have, for example, setbacks from the roof that are required for fire code. That would be a health and safety reason as to why you would restrict, a solar project that a local municipality could enforce and could work on. And then you move down one more, you drop off solar. Now we're just in wind land. In wind, the Public Service Commission had developed back in 2010, actually Eric was involved with this process, the wind siting rules. And those are statutory administrative code provisions, which are the maximum amount of regulation that a locality can place on a wind energy system that's under 99 megawatts. And there's a permitting process that can be set up so that the locality can permit these wind projects, but then there's an appeal process to the Public Service Commission so that there's oversight of that local process to ensure that those rules are being applied fairly. So that's my short as I can make it answer on the pyramid of clean energy siting under 100 megawatts in Wisconsin.
That's an excellent answer, and that's why I go to you for legal questions. Isaac, as someone who works to manage comprehensive land use planning in your county and drafting zoning ordinances that align goals of the county with regular uses, when your county considered redrafting or drafting rules on solar and battery energy storage, what were the top concerns you had in mind?
Yeah, thanks, Sharif. I guess the top concern was catching up, the lack of existing regulations regarding solar, wind, and battery energy storage facilities. So that's not something we really had on the books. So we did have an applicant reach out to us a year in advance to say, hey, this is a pending application coming in. So our first and foremost concern was we need to have something in place so that we don't have the unguided development in the county. And then next within that packet was, what are our elected officials, our county boards, our zoning committees, what are their concerns regarding solar and how they view it? And then really it was getting something drafted and through the approval process within the timelines allotted by state statutes and having something that can meet the limitations or guidance of state statutes with regard to the ordinance and what powers the local jurisdiction at the county, what we do and what we don't have, in sorting that out. And then just establishing regulations and a process that allows adequate review. We work closely in Outagamie County with our towns. A majority of our towns do have or have adopted county zoning, but our relationship is still close with them. So through the approval processes, they are part of that and making sure they're part of that conversation going through it. And then, just getting it through the process and having it in place was the biggest concerns with the use.
And how do you balance, concerns from the towns or concerns from residents with how does that process look like?
I don't know if we've achieved balance, but it's an ebb and flow, quite honestly. We as staff try to educate ourselves as best we can on the topic. No matter how much give and take there is, there will always be town representatives or the public who are just not willing to accept the use as is. But typically when we're looking to adopt new regulations, we're going to seek stakeholder input, hold public hearings, have advisory committees, and then we'll look to what do we have on the books for existing processes and regulations, and through the test of time, do those work, and is it something we can compare to that and use similar operations for it? And then we do look to surrounding jurisdictions, right, where we don't have to recreate the wheel. As local government, we have a lot of hats. We're doing a lot of different things. So we'll look to see, for us in Outagamie, has Wapaka done something like this? And if so, is it working? What's the feedback? Is that what we want to do, or do we want to do something different? And then beyond that, we look to other sources, whether it be the Wisconsin County Code Administrators, APA, UW Extension, and see what's out there. And in the case for solar, we were able to find the Wisconsin Model Solar Ordinance that the Great Plains Institute had put together, and use that as a solid base for launching our regulations with regard to solar, and found so far that it's working. So.
Isaac, sorry, David. In your role, you play a really important role in engaging with the communities and local officials. There's a lot of education and collaboration that needs to take place, and information sharing to figure out how to develop responsibly and transparently. So in that role, what were the most common community concerns you met, and how did you credibly address those issues?
So I'm going to start just by saying that while there is a statewide process for approval of utility scale projects in Wisconsin, that does not mean that you should cut out local community engagement. It remains critically important to let your local officials know what you're up to and to answer those questions. They will likely participate in the state process, but even more than that, your goal is to have a successful project, right? So you don't want to make life hard for your HR team when it comes time to hire people who are going to work there, right? So, and even beyond that, I've never met a developer who does not lead a conversation by saying, we want to be a good neighbor. So you got to put in the work to be a good neighbor. When you think about concerns, they're going to be fairly flexible between localities and the experience of those localities. But typically with solar, it's going to be things like loss of farmland. It's going to be, are the panels going to leach? It's going to be, why are you building here when the sun never shines anyways? With batteries, it's pretty much fire, toxins that would come off of that fire. And then in some communities, it's leaching, which is a concern that's based on everybody's personal experience of reaching down into a cabinet and finding a lead acid that has exploded, and then imagining that happening on a 12-acre scale with a 200 megawatt project, right? Even though it's a completely different technology. So what I found is really important is to engage with folks pretty early on in the process, and we can talk more about what that looks like later on if folks want to. But then also taking the time to bring in experts. And I'm not tooting my own horn here. I mean, bring in a fire safety expert if you have a battery energy storage project. Bring in someone like Isaac who has solar in his community to talk county staff to county staff about what this solar project means and what you've heard. People are going to have skepticism about anything that a developer tells them. Even if a developer is citing third-party references, having those third-party individuals come in and speak is really, really, really important.
Excellent. So I want to pause here and just give an opportunity for the audience to ask a couple questions, and if not, we'll move on to the next question.
I think for Isaac, if you're in the industry and trying to build solar, wind, batteries, and you at the county level are trying to have an educated and participating community, do you have any recommendations for how developers can do that in a way that, obviously doesn't inflame tensions or make things worse?
Yes, in short, we have a process in place. Communication earlier on is best, is what we're finding. Then there's no surprises. We have time to prepare. That may mean setting up additional community meetings outside of planning commission or town board meetings, just as informational, and then having those contacts, because where there's the vacuum of information, we find it gets filled very quickly with a Google search or whatever else, and we've got stray voltage concerns. We've got all sorts of things fired across our desk. So we at the county hold a pre-application meeting for any kind of conditional use, and that's the opportunity to get the developer, the town representatives, and the county staff in one meeting and start to discuss the proposal and what next steps are through that process and help them guide it. But in short, what we've seen to be successful is having, whether it's a one-sheet informational pamphlet, frequently asked questions. And our town officials really love that. Even as staff, we get those phone calls. It gives them that tool to address those questions. Because if they don't, their initial response is change. Let's push back on it. We don't want it. And I think just seriously open communication earlier as you can and start that dialogue.
Yeah, I was going to say one thing on this too, and just to follow up, it's great advice from Isaac. It's almost developer malpractice if you don't go into the community early and often, certainly before you have a formal county or town meeting, right? The county or town meeting is a formal process. It's a public meeting. It comes with people fired up already because they want to make their point in front of their elected representatives. A good developer is going to try and address that in advance by having meetings before that. You've got to get out there in the community and work the community in all the right ways. Otherwise, you're going to have problems at that first meeting.
I want to add something just that I've found, like, I'm an attorney, so I like to seek out other attorneys, right? But I think it's less about finding the lawyer and more about finding who on staff or on the town board or on the county board is going to be the leader, and finding out who on your team connects with that leader and can be the person who provides them that information that they need. And it's different people in all sorts of different positions, so there's never a one-to-one. Sometimes it's the attorney, sometimes it's the comms person. It can be literally anybody, but it's important to find who that is and then work with them. I think that's really key.
Yeah, one thing that we really try to do in our work is find someone local to have those conversations, because if you're bringing in someone from Texas or Omaha or California or even Chicago to talk to people in rural Wisconsin, you're already stacking the deck against yourself. If you can find a person who knows Wisconsin and can name several years of offensive line members of the Packers, you're in better shape. I also wanted to give a sense of what Isaac was talking about in practice. What we have right now is an environment where it's very easy for, say, a Facebook page to blow up, right? There's anti-renewable energy pages across the country, and they follow each other. And so when someone starts one up in Wisconsin, you can bet the team in Michigan is going to be giving them tips, and they're going to be talking to the folks in Kentucky and the folks in Washington State. So it's going to grow extraordinarily quickly. And the thing that can often trigger that is a letter from a land agent. So this is really, really early on in the process, right? Where someone may get a letter from a land agent that says, hey, we're looking into the possibility of developing a wind project in your community. Well, then they freak out, they start a Facebook page, and the next thing you know, they're going to contact their local elected official. If that local official doesn't know that you've been in the area prospecting, you've already lost. And it's as simple as reaching out to the local economic development person or local planning staff and having a really early conversation that says, hey, has anyone approached you in the past? What did you hear? We're interested in doing this. This is what we'd be interested in doing. So then that staff can brief the electeds so that when someone approaches them after church on Sunday or at brunch or at a Little League game, they have the information and they don't feel like they've been caught flat-footed.
There's a microphone in the middle if you would like to use it.
Kind of loud, so hopefully. My question actually goes a little bit more toward storage. So in the solar industry, you see local jurisdictions doing a really good job of referencing, you already referenced Great Plains Institute today, but there's other resources, the State Planning Association, those sorts of things. Where are local jurisdictions looking for information for storage so that we understand what message they're delivering to the state on storage?
Great question. I'd say we are in the process of looking for information. We do have battery energy storage as accessory to our solar uses in the ordinance right now. But we are going through a much larger comprehensive rewrite of all the codes for the county currently. But I'd be very open to getting some additional resources on that and educating, what are the best approach? What are the pros, cons? How do we regulate that?
I mean, the developer can always tell you, right? But it's,
Unbiased would be,
Right.
or
and
both
we're seeing
sides.
moratoriums. So this is where I'm wondering if everybody's getting organized or not, but I'll let you guys.
Yeah, I mean, I can talk a little bit about a Wisconsin local experience. There was a moratorium in Kenosha County so that they could figure out what they wanted their best ordinance to look like. And they actually went out and found another community that had drafted one. And, that's great because then it's not coming from the developer, it's coming from someone else. Now, that ordinance has a couple problems with it, to be sure, but it's an iterative process, and it's one that, when you are a developer, you expect to find things that aren't perfect, but you need to be able to deal with them. So I think that's one that grows, and maybe you take that ordinance and you take it to the person who's reached out and you said, have you seen this? Have you worked with this? What are some of those flags that you've seen before? I think you also have to be a little careful. Talking about the solar context, there's a big boom in Wisconsin of certain individuals hawking solar and wind ordinances that were preceded by state law or in violation of state law. And kind of the parking lot conversation afterwards was like, hey, we just got hosed out of some legal fees here for an ordinance that doesn't work. So I think connecting with the groups that Isaac was talking about, the towns, counties, making sure that you're vetting these things, that you actually get, is really important because there's some junk that's being sold out there that doesn't help anybody, to be honest. That's where I would land there.
Yeah, and I would say, Ori, that if you are looking for examples of ordinances in Wisconsin, look at Kenosha, look at Two Rivers. Those are two communities that have ordinances in place, and that can be a good starting point. Another thing that, in my experience, we've seen communities do is look to adjacent states that have seen a little bit more development than has happened here, and Illinois has standards for battery energy storage. They're very developer friendly. That's a flag that I am willing to give, but that's one as well. But I would start with Two Rivers and Kenosha.
So we'll take one more question and then, sir.
Yeah. Turn it on. It's on the top.
I'm hearing a lot of discussion on the need for open communications and what I'd call the no surprises, especially for elected officials and staff. Could the panelists discuss our non-disclosure agreements used in the siting of wind, solar, and storage, like they've been used in data center discussions and siting? And what are the pros and cons from your different perspectives of non-disclosure agreements?
Yeah, I'll take it first. So NDAs are pretty common between the developer and landowners who are signing deals with the developer to put infrastructure on their property. They are not particularly effective. And I think developers acknowledge that. So, sometimes your lawyer talks to you and says, this is best practice, do it. And the developer nods and does it, but knows, in fact, that the price per acre is going to be made public and all the other material terms of that agreement are going to be made public. So they do exist, but they're not particularly effective. And you do wonder whether they should continue to do that because it just puts landowners in an uncomfortable position and starts to pit them against neighbors unnecessarily, but it is common practice. But curious to hear other thoughts on that.
Yeah, I haven't. When you're talking about the data center context, I think you're talking about with the actual local communities. I haven't seen that be part of the process in the same way. that it is for data centers. And I think that just goes to the development industry and professionals that work in the renewable space have been doing this maybe a little longer and have gotten a little smarter. So when it comes to being a good neighbor, they want their political allies out there talking about the project. They don't want them, hiding something. So I haven't seen that in the same way.
Yeah, I would agree. I've seen the Facebook posts that say local county elected signed an NDA with a data center developer. I'm skeptical, to be honest. That would almost certainly violate the ethics for an elected official to do that. So just to be clear, I've never seen a renewable energy project attempt that. I would, frankly, for very dark reasons, love to see what the response would be if a utility scale solar developer went into an elected official's office and was like, yeah, you got to sign this NDA. They would most likely get thrown out of the room.
Great discussion. And Isaac, I wanted to ask you, so in the past, some counties or towns, make the mistake of lumping every, category of use together. And, that runs into, legal issues with state law on local governments not being able to legislate on this issue. When you have different uses of solar, you have, rooftop solar and then, small projects, larger projects that are smaller than utility scale ones. How do you differentiate between them in zoning so that, you're not burdening homeowner use of solar panels?
So what we did, and again, using the example from Great Plains to help launch our ordinances, I think clear definitions as to what we consider each solar category to be. We adopted 4 main solar categories, from accessory solar to community solar, large scale, and then utilities, what we would consider in our ordinance over the 100 megawatts or greater. And in doing that, clearly defining what it is. So with accessory, it's just that there needs to be that principal use on the property, and then your solar there is serving, and the power from that solar, accessory solar, is serving that principal use. Accessory solar, we have as a permitted use, so there is no conditional use or special exception process to go to. You've already gone through the approval process for your permitted or your principal use, and it's accessory to that. From there, we kind of had to try and figure out what we decide or what we consider to be community scale versus large scale. So we drew that based off of acreage initially. So our community scale is 20 acres or less, and that can be power that's either used, on site or sold wholesale. And then 20 acres and larger, we put into our large solar category, and that goes all the way up to 100 megawatts. And then utility scale is over, and that we made a permitted use essentially in every district as it goes through the PSC. That's how we categorize that. And then I will say there are some counties that are trying their best, or trying, I shouldn't say their best, but are trying to regulate the 100 megawatts or over. That's not something we wanted to get into or even approach. And setting ourselves up in between property owners with expectations that we have some say in it, hearing their thoughts and their concerns, and then having to essentially ignore them because we don't have that legal ground.
And Eric, so there's a similar type of distinctions in the Public Service Commission regulating energy development. You have different concerns when it comes to fossil fuel, as you have with wind or solar. How does the commission consider, the larger footprint, local footprint of renewable energy projects compared to fossil fuel generation? How does that shape their decision making?
Yeah, so the statutes that govern the commission in this area have not really been amended in a material way in decades. And so they contemplated large central station generation, large coal plants, large natural gas plants, right? So they were not drafted or written in a way that ever thought about a 1,000-acre solar farm. That being said, The commission has broad authority to interpret the statutes and does look at those projects a little bit differently, but not in a large way. There certainly is a concern that the commission takes into account for the impact of a large solar project on things like farming, on things like visuals, which tends to be less of an issue for people who are further away from a coal plant, right? A coal plant has a major material visual impact on those who are right around it, but not a lot of people live right around it. A solar project, obviously, a large one, is seen by a lot more people in the community. So they take all those things into account. But as a former commissioner, and this may be a statement that is controversial, there were two elements to a CPCN, two fundamental elements to granting permission for a large project. And I'll talk about one that a utility itself is building. The first is the project needed? So is there a need for this project from an energy perspective, and from particularly a utilities perspective? And then once the commission reaches that, then can we cite this in a way that is consistent with the statutory requirements on siting, which take into account things like aesthetics, impact on environmental issues, et cetera, and local land use as well is another requirement the commission has to look at. When I was a commissioner, if I got to a spot where I thought the project was needed, it was going to be very challenging for me not to cite that project, right? It's a tough decision. But if you need the project, then we've got to figure out a way to cite it reasonably. And so I think that's the spot where there's lots of opportunity for successful input at the commission. I'm not going to sit here and tell you that you're going to have great success at stopping a 200 megawatt solar farm. It's actually unheard of so far. When I was at the commission, we did reject a coal plant. So you can get plants rejected, but in the current environment, with the cost of renewables and the other benefits that come with it, it's going to be tough to actually stop that plant from going in. But what you can have an influence on is the things that matter most to local governments and to local citizens. What does it look like? Where is it going to be sited? Can we push it back further? Can we get more money for roads? All those things the commission can take into account and address. So in that way, it's not different than a large coal plant, but I think it does have more of an impact on more people, and the commission is sensitive to that. And it's gotten better at dealing with that the more projects that it has in front of it.
I think that answer really goes well with the next question for Ori. So for smaller projects, Eric talked about some of the considerations that the commission makes in their approval. How do you explain the difference in smaller projects between the local authority to regulate zoning and land use for health and safety compared to the Public Service Commission's authority?
Yeah, I do think that's where there is a little bit of a gap that's incumbent on the developer to fill, especially, and we're talking in the solar context and the wind context here, but especially in the solar context, because you have that limitation, I think it's incumbent on the developer to come with solutions that they may not be legally required to give. So the Public Service Commission has actually done a lot of great work giving you an example of what successful mitigation measures might be, whether that's screening in the form of, trees, coming with noise studies, glare studies, that type of thing. In the battery context, coming with fire safety studies, and that can apply in the solar context as well. But there really is quite a limit on what health and safety really does mean. And I think that limit should be read pretty strictly from a legal perspective. Is a visual impact health and safety? That's going to be hard to justify if you don't have substantial evidence that, however you're actually technically regulating that, is a health and safety reason. So, for example, if you say I'm going to require a mile setback on this 5-acre project, because of health and safety, is there really substantial evidence to support that the noise or the visual impacts of the project require this mile setback? Probably not, and not in a way that connects to health and safety. So it does get very in the weeds, it does get very in the facts, but I would encourage folks who are looking to cite these projects and regulate these projects to look at what the PSC considers and has done work on, because I think that's a way you can root yourself in that substantial evidence standard. And I also think when you're a developer, you don't want to go in waving that around as your stick. Your stick is, we've developed a great project, we've made some really great local measures, and this is what we're going to do for that project. And then, when you find that smart attorney or smart planning staff member, you want to say, and also, by the way, I think I'm on pretty strong grounds here. I have some concerns about this. Can we work on this case-by-case basis and resolve those? So I hope that answers your question, Sheree.
Yeah. David, there is certainly a gap between what local governments can regulate and the interaction between developers and the local governments. What role does joint development agreements and communication of the community benefits and utility aid payments, what role does that play when you're reaching out to local governments?
It can be critical. And there are many ordinances that require some sort of economic benefit agreement for the community. You can call it a joint development agreement. You can call it an operations agreement. Whatever you call it, it's additional money that the project will deliver to the community. It's really, really, really important to, if possible, work with the community to identify a need that money can address. So you're not announcing that you're cutting a blank check to the community, because opposition will call that a bribe. And they will use that to get a lot of folks angry about your project, even if the money is going to go in and help. Work with your local AHJ permitting authority to learn about what their revenue is in this year. It's all public information, right? And how will your contributions help them moving forward? Because it could potentially reduce demand on taxpayers and people like that, right? So talk to them about what the need is, what it's actually going to mean to the community, and go from that angle. I wanted to add a couple of things to what Ori said too. If you're a developer and you're coming into a community with a solar project, also have the information about other projects that you've done in Wisconsin. The industry as a whole could really improve this, kind of closing that feedback loop. Have those stories from the communities that you've already got successful projects in, and bring those with you so that the local electeds and staff can feel comfortable that you can be a good neighbor and that you will be a good neighbor. One pet peeve of mine, and I know this can make people angry because they think you're hiding the ball. Developers love drone shots of utility scale projects. And they go into communities that are worried about visual impacts, and they serve them up an image that's been taken from 700, 800 feet above a project that no person standing on the ground would ever see. No person driving by in their SUV would ever see. Some of these developers have contracts with solar sheep herds that come onto their farms and help them with grazing and vegetation management. Show me a picture of a lamb in a solar field surrounded by wildflowers. Don't give me this super engineered dream of 1 billion acres covered with glass, because it's not going to help you out.
So I want to open the floor again to questions, just so we can get a few before I. Go ahead.
My question, this is Susan Muller. My question is whether there's any talk about the importance of having local energy as opposed to imported fossil fuels. I know that many people in rural areas are interested in having local independence. I just haven't heard, and I'm wondering if that ever fits into any of these processes that you're discussing.
Well, I mean, certainly community solar is an issue that's highly debated in Wisconsin, and Renew Wisconsin supports a community solar bill that's currently pending in the legislature. We'll see if that makes it out. That would help with, help with locally provided energy. The challenge for larger projects, and I had a conversation earlier today with a developer on this, and we don't have an answer, is that these projects are all going to be fed into the grid. So it's very challenging to tell a local community this 200 megawatt solar project is going to go from this panel to your meter. It's not, right? The electrons go where they're going to go, and in a perfect world, the local utility buys that project, and so then you can kind of make a credible argument. But that's not always the case. So it is a challenge, I think, for the industry, and maybe you have a better way to communicate that. But I've always struggled with saying, oh, no, this solar's not going to come to your house. But that's the truth in many cases.
Yeah, I think that's a bigger messaging issue at the state level, and I think there are some initiatives in Wisconsin. I know Chelsea at Clean Wisconsin had been working on an initiative to create that messaging, but I think it's at a state level that messaging needs to start, because it's at the state level where you're making the decisions on, okay, we're bringing in energy, from outside. So you need to start communicating that there, and then, give folks resources that they can take down to the local level and make that communication known.
Yeah, there's a joke in the comms world that if you're building a project east of the Mississippi, all of the energy is going to New York, and if you're west of the Mississippi, it's all going to LA. What we typically tell people is to think of water distribution. It's similar. The power goes where it's needed. There are maps that we have, especially now, that are looking at capacity by county level, and you can show, look, your county needs power pretty badly, and you can say that if you build this locally, it's likely to support. Now, the one difference is if your point of interconnection is feeding to a power line that runs right out of town, you can't do that, because someone in the opposition will know that is going to tie in and run right out of line. And then just the answer is, look, everybody in MISO needs power right now. And by building this project, we're going to help everybody out.
And a follow-up from a local level. I mean, the conversations are starting. I know in our county, we have the third proposal for this, which is starting that buzz, right? The towns associations are talking. I think from my perspective, it would be great to have, an overall plan. I think a question will be, well, at what point are we meeting our needs? How many of these facilities should a town or the county look at considering in the future? Will there be an ideal maximum at which point we'll have what we need? And that might help them put things together. If we are more independent locally, you can reinforce that local grid. It's almost more of a security or safety netting. And I just don't think they understand that a lot of it is you're taking advantage of our community. You're flipping what is agricultural land into something that's industrial. But I think as this use grows, especially in the county, and people start to see these facilities and how they operate and what is the ultimate goal, that'll help them understand the process better.
Is this on?
I think it was on earlier. I could hear it earlier.
I'm actually a resident of Outagamie County, but my question is about how do you deal with absentee owners. I think there's that's a real challenge in that you could have fairly large farmers that are farming in one township and they live somewhere else, and that how do you communicate to the local community that's going to end up hosting that solar facility?
Yeah, I'll take a sort of a blunt approach to that. It's landowner rights, right? If somebody came to you and said, I'm going to limit what you can do with your property, you get the hair on the back of your neck stands up, right? So the fact that somebody has worked hard and has developed a large farming operation, they don't happen to live directly in the community where their land is not unusual. I don't see it any differently. They're hopefully a good tenant of the community. They're taking care of property, and so they should have a right to use their property the way everybody else does.
Yeah, and I'll expand on it. It's these things aren't done in a vacuum, especially once it gets across the desk, whether it be at the town or the county. There are procedures for putting out public hearing notices and advertisements for this, and some of our towns do start with notification to neighboring property owners within 300 feet, 500 feet. And once that starts with social media and everything, now the word gets out pretty quick as to what somebody's looking at doing.
I recommend that my clients talk to the folks who are using that land to farm. Because if you have an absentee landowner who's got someone who's been using that land for many years, or is a farmer who's just starting out and is using that land, they could actually be putting somebody out. And is there an opportunity to work with that person? But that to me is another area of a pretty easy to fix cell phone. You're already doing good neighbor agreements, like maybe consider doing something to help out someone, help them find another property that they can farm on, and just, think about it a little bit more deeply.
That's the communications guy versus the lawyer over here, so I get it. But that's why you need both of us.
Well, I cut into everybody's lunchtime. If we have, one more question or call there. Go ahead, quick question.
Just really quick, I'm curious if there's any insights about rural electric co-op areas versus anywhere else in the state. Any insights about restrictions?
Go ahead.
Yeah, I can take that one a little bit, and I'm sure Eric can help me out. Co-ops are a little different in Wisconsin and how they're regulated. They are, for siting of the utility scale projects, they still are cited through the Public Service Commission. But when you're talking about a co-op, you're going to be, I'm guessing, talking about the interconnection of maybe a smaller facility with that co-op. And in that case, the co-ops may follow state policy, but they also may not. And I think the question there is, do they have, some of that evidence that it explains what their policy is and why it is the way it is? And co-ops, unlike other entities at the state level, I mean, they're more like a county or a town board. So the cool thing about a co-op is you can go talk to your co-op representative and work on what does this look like. And that's usually the first point of contact, that you want to have. I can knock through the legal sense of, what has FERC said about this? What is the federal law? But that's generally not the way forward in those instances. It's usually how can we work together to find a policy that makes sense, and usually grounding it in the state process. Co-ops usually on the western side of the state. Sometimes they like to look to Minnesota. Grounding it in their Minnesota process or in their Wisconsin process is helpful, and saying like, come on, guys. But it's more of a political process than it is a regulatory and legal process for the co-ops.
Okay, with that, I want to thank everybody for joining us and thanking the excellent panelists. I think as the Wisconsin undergoes this renewable energy transition, we're going to have these conversations more and more as we figure out how do we balance the community and local interests with statewide goals. Thank you all.